Welcome to Employment Law This Week. I'm George Whipple. Our top story, the Illinois Appellate Court weighs in on social media and solicitation. The case involved a defendant who sent LinkedIn connection requests to 3 former co-workers, even though he had signed a non-solicit agreement. In considering whether social media activity violates non-solicitation agreements, other courts have drawn a distinction between passive social media activity and more active direct activity. Though these requests were made directly to the former co-workers, the court, in this case, ruled that the content constituted passive activity because the defendant did not discuss his new job in any way, nor did he directly attempt to recruit his former co-workers. The court concluded that sending the connection request did not violate the agreement. Brian Spang has more.
This particular agreement only prohibited direct inducement. It prohibited the employee from inducing other employees to leave. It could have and should have included a restriction against both direct and indirect inducement. This is important because the court pointed out in multiple places that there was the plaintiff did not present any evidence of direct, quote-unquote, inducement. Second, I think that a non-compete or non-solicit agreement can specifically reference social media as a potential avenue for violation of the agreement.
Paid family and medical leave comes to Washington State. Washington joins an increasing number of states mandating paid and protected family and medical leave for employees. The law, which takes effect in 2020, provides the most generous mandated income replacement benefit for paid leave in the country. It provides for up to 90% of an employee's income for as much as 18 weeks of protected leave in a year. The law applies to employers with 50 or more employees. Payroll deductions to fund the benefit may begin on January 1st, 2019. Congressional Republicans ready new joint employer legislation. As we reported here on the show, the Department of Labor has withdrawn the Obama-era guidance advocating the indirect control standard for joint employment. The NLRB could be the next target. Republicans in the House are planning to introduce legislation that would overturn the board's controversial Browning-Ferris decision, which first established the indirect control standard. The legislation is expected soon and could include updates to the NLRA as well as the FLSA. Mortgage underwriters are not exempt from overtime pay, the Ninth Circuit says. A 3-judge panel found that underwriters for a savings bank did not qualify for the administrative exemption to the FLSA's overtime requirements. Reversing summary judgment in favor of the employer, the court noted that the underwriter's job duties were aimed at producing a reliable loan rather than at administering or managing the business. With this ruling, the Ninth Circuit aligns with Second Circuit precedent, but reaches a different conclusion than the Sixth, which found that mortgage underwriters at a different bank did qualify for the administrative exemption. Now for our tip of the week. Helen Skinner, Senior Counsel for the Panasonic Corporation of North America, is here with some advice on employee benefits and compensation considerations during the M&A process.
In mergers and acquisitions transactions, moving or transferring the employees successfully from the seller to the buyer's organization is critical. When looking at integration, it's really a question of where the acquired entity is going to fit into an ongoing business. So there are issues of parity, for example. Are the new employees, are they going to be sitting and integrated with the current employees? And if so, does that mean that the new employees need to be on the same compensation scale? They need to have similar benefits. Caring for these types of issues is often critical to making sure an M&A transaction closes successfully.
Thanks, Helen. That's it for Employment Law This Week. Thank you very much for watching, and we'll see you next time.